And the whole goal here is just more transparency for buyers. So if you are buying a unit in a common interest community, you are entitled to information about the existing association, things like, is there pending legislation against you? Has the board been naughty? And have they not been, enforcing their laws in a fair way? Do I want to join this community? And it's so interesting because WUCIOA gives buyers a 5-day period to back out.
Hello, Adriana. Thanks for coming on with us today.
Hi, Jeff. Thanks so much for having me.
Nice to meet you, Adriana.
It's nice to meet you too, Linda.
So, Adriana, we have this thing, Wakaiwa. If I even have the terminology right, I've heard it said something a few different times. So, walk us through the history of it. What's changed, and why is it important to brokers and other people today?
Sure. So WUCIOA is the Washington Uniform Community Interest Ownership Act. And that's why we call it WUCIOA, because that is a mouthful. Um, it is going to govern and already governs some common interest communities. And I'll define that off the top. Common interest communities are residential communities where owners own individual units, but then also have broad co-ownership of common elements. So things like sewers, turnarounds, right-of-ways, that kind of thing. Sometimes like playgrounds. If you go to a single family residential plat community, you'll see that there's a playground that's maintained by everybody. And the reason we're enforcing WUCIOA soon, starting for everybody in 2028, is for a very long time, in my opinion, there's been a need to make uniform and modernize the way that we're governing common interest communities. Prior to 2018, there was the HOA Act, there was the Condo Act, there was the Cooperative Act, there was, all of these different bodies of law governing all of these different types of communities. So what I would see as an attorney is very confused boards, very confused members, um, lack of cohesion just in general when it came to governing these communities. So what the Washington legislature has done is make one body of law that will govern all of these different types of communities.
Got it. So, which communities are automatically governed by Wakaiwa, and can existing ones opt in or in some exempt?
So communities that were developed after July 1st, 2018, automatically come in under the act. Pre-existing communities can opt in, which is going to require an amendment of their governing documents. And that's, sometimes where I come in. And then starting January 1st, 2028, everybody is going to have to comply with this. So the reason we're urging people to opt in now is because if, hey, January 1st, 2028, you have these things that you haven't updated since like 2011, your entire association is not going to be in compliance any longer. So it's usually my job to go through your amendments, your CCNRs, your declaration, and make sure that what you're doing is in compliance with the new act.
Good. So, what do brokers need to know about resale certificates and public offering statements under Wakaiwa?
So under WUCIOA, new developments are going to absolutely require public offering statements, and these resale certificates are going to have to comply with, I would say, stricter requirements. And the whole goal here is just more transparency for buyers. So if you are buying a unit in a common interest community, you are entitled to information about the existing association, things like, is there pending legislation against you? Has the board been naughty? And have they not been, enforcing their laws in a fair way? Do I want to join this community? And it's so interesting because WUCIOA gives buyers a 5-day period to back out. So once you have this resale certificate, it is your job, buyer beware, to look at the contents and figure out, are there discrepancies? Or did you say you attached this thing and you didn't? And the confusion sometimes is what is the duty of the seller? So that's why it's important for brokers who are especially representing sellers, because on one hand, it's the seller's duty to obtain the resale certificate and reasonably, discern whether it is accurate. But the HOA itself or the association itself has, in my opinion, the broader duty to make accurate disclosures because only that board is going to understand what's going on with them.
Regarding the new governance and transparency rules coming in SB 5129, what changes are effective January 2026 and how should brokers advise boards?
So there are some changes happening. Some of them are with like electrical vehicle rules and, putting in charging ports. But the most important changes, in my opinion, are around board governance. So all meetings will have to be open except for executive meetings. And resale certificates are going to have to be more robust. They're going to have to start, following those better disclosure rules. Um, there are quite a few changes contained in SB 5129, which is why, people are confused because some of the act is going into enforcement and some of it is still trailing behind and won't go into effect until January 1st, 2028. But the most important ones are around board governance and voting. For example, owners automatically get 15 minutes, to comment on something before there's a vote. And voting has to be accessible by telephone now. And, you know, all of it is still in line with more transparency, more trust, boards, complying with better, more uniform rules. So board training and that kind of thing is coming into effect too.
Okay, got it. What should older communities do now? Should they restate or amend their governing documents before the full WUCIOA compliance in 2028?
In my opinion, that's the best thing to do. So, kind of like the firms that I'm coming from, a lot of older attorneys or partners drag their feet when it comes to things like AI or case management software because the onboarding procedure is heavy. Like that's a heavy load. So it's a lot upfront to take care of these kinds of things. But in the long run, you're already hitting the ground running when January 1st, 2028 hits. So instead of panicking, being automatically out of compliance already, you and your board can sit in the comfort of knowing we've had someone look at this, we've opted in, and not only are we compliant now with these 2026 changes, but also with 2028. So we're ahead of the curve.
Okay. And how do the implied warranty rules affect newer condominium developments? And then what are the exceptions for upcoming DADUs or units under 12?
So implied warranties are now explicit for new developments, things like the implied warranty of habitability. So, builders have to now warrant their work and just say, this is adequate, this is livable here. And the current exception is for communities with 12 units or less, and annual dues are less than $300. But soon that will change and expand to communities that have 50 units or less and dues that are $1,000 or less. So that's kind of the trick there is that the coverage will expand. So it's really important for those communities to, gauge, oh, are we going to fall under these rules now too?
Okay. And what's the timeline for brokers and boards to move from the optional to mandatory compliances? And how should that shape a broker's advice to clients?
So January 1st, 2028, everybody remember that. Like that's when everybody is going to have to fall in line. And brokers now, what they can do is pay attention when they're selling these common interest community units to the resale certificates and sometimes to the public offering statement if it's brand new. Are these accurate? Is there someone on my team who I can, tap their shoulder and say, does this look right to you? Because as much as the act is unifying everything, the reason it's unifying it is because there's all these little subtle differences between all of the acts. So, like I've said, brokers who are attending the class that Jeff and I did together are, arming themselves with this educational material now are going to be way, way, way ahead when it comes to protecting buyers and sellers, frankly.
Okay.
Which is good. So there's a lot of confusion out there, a lot of learning, and I'm glad it's being phased in because it gives brokers, sellers, buyers a chance to kind of get educated before it's fully upon us. So I appreciated the class that you were teaching before. I learned an immense amount from it. I've still got more learning to do. And I know there were some questions that came from brokers that still, after going through a class, you're still asking questions. So like, I mean, simple things like, rapid fire questions here. What's the definition of a mixed use community under WUCIOA?
Mixed use is residential and commercial. So I'm thinking like Totem Lake in Kirkland, it's apartment buildings up top, and then it's commercial businesses down below.
So what's the definition of a non-residential community?
Let me not use legalese. It is a common interest community with no residential units except for employees. So if you've got like a property manager who has a live-in unit, not going to be residential.
Okay. If an HOA is formed as a corporate entity, but the HOA is no longer operating, has been disbanded, what should the HOA members do?
Sometimes you should revive your entity. That would be my preference so that we know that there are people paying attention and, making sure that the community is in compliance, or wind it up and just officially, dissolve it if it has not been administratively dissolved already. But this is relevant to the resale certificate in that there is a single exception for obtaining a resale certificate. A seller has to prove that they have made like 3 good faith attempts to get in contact with an association, and they can't get a resale certificate. And only then can the buyer waive their requirement. Because the logic was that 5-day period to back out, if you see something in the resale certificate, if the poor seller is trying to get the resale certificate and they can't, buyer can extend that back out period 5 days at a time. And we just gotta, you have to put a stop to that at some point.
So what if a common interest community has CCNRs but has never had an HOA?
That would be very interesting. And associations are interesting in that they're formed under the Nonprofit Act. So if you have CCNRs, those were likely established by your declarant, the person who, established the community in the first place. But you have to have an association. So under WUCIOA, you have to have an association that has all the powers transferred from the declarant to, the association that will enact the CCNRs. So it's kind of weird if you have them, but there's nobody to enforce them.
Right. So what if an association board does absolutely nothing to address the WUCIOA changes?
Well, they're going to be out of compliance January 1st, 2028. And it's interesting because board members have duties. They have standards of care that mirror those of a nonprofit board. So if they're not doing anything and they're not paying attention, in my opinion, that would be grounds for a lot of lawsuits. And I frankly do think when we're getting closer and closer to 2028, we're going to see a lot of those gearing up because people are going to get nervous. Sellers will not be able to sell if their entire community is out of compliance.
Mhm.
Well, good. And again, this is so much of a learning process, and that's why we're really lucky to have someone like you come on with us and share about it. So tell us a bit more about your background and your current job.
Sure. So I recently went solo. I haven't been licensed actually for more than 2 years yet, which is odd in my opinion. I know a few people who went solo immediately out of law school. Hats off to them because that's really brave in my opinion. But I spent about a year and a half officially licensed with like a mid-sized firm. And then prior to that, I had experience, just being a summer associate. I clerked for a little bit in an internship with the Washington Supreme Court. So when I was at mid-sized firms, I was noticing, I have a restaurant background. I also have a law enforcement background. When I was at UW, I worked for UW PD in their records department. So I'm very attached to UW. I really loved my time there. But in my restaurant jobs, in my, public facing records job, it was my duty to hold people's emotions. And I think when we represent people, even in just real estate and property disputes, emotion is still high. Just because it's not criminal and just because it's not family law doesn't mean that people aren't really attached to things and property that they've often put their soul into, put a lot of effort into. So what I was noticing is I think some attorneys, they spend so much time in the game that it's all about the law. And I wanted to go solo so that I could infuse what I do, technically with more emotional intelligence and with more, customer service care because, it's people's lives and it still really matters. So now I have the freedom to be more flexible, to teach classes, to develop my own curriculum around these kinds of things, to make it easier on people as we move forward so that anyone can use the law as a tool, which is what it is, instead of, being very freaked out about it because of how complicated it clearly is.
Yeah, that's really warming to hear. So if you could share just one piece of advice with us from your career, what would it be?
Well, I have this tattoo like right here and it says, "Why not?" And I got it in law school. And it's based just in being a woman of color, being a very young woman of color in a male-dominated field, being an Asian woman in particular in a field where, the strong advocate is like the big, tall guy with the big, loud, deep, booming voice who's just like the bulldog.
Hmm.
I don't fit that, I think, aesthetically, but that's who I am. Like I'm absolutely that bulldog. So that phrase, why not? It's when you encounter people who are naysayers, when you encounter challenges, when you encounter things that make you question what is possible, ask yourself immediately, like, well, why not me though? And put yourself out there the way you would want someone you love to put themselves out there.
Hmm. Yeah, I always admire the people who are the why nots rather than the whys.
Yeah.
So do you have a favorite book or recent books that have like greatly influenced your life or career?
Yeah, so I am in the middle of Unreasonable Hospitality, and it kind of, connects back to my restaurant experience. The author is a fine dining guy who's been in the industry for like his entire life. I was a line cook at a Mexican restaurant and like a waitress, nothing like that. But it does touch on the importance of emotional intelligence, not just in interacting with customers and clients, but in the way that you interact with your team. So another issue I encountered at bigger firms is a lot of attorneys don't treat their staff very well. And as a result, the quality of the service suffers. So I am trying to use the things I'm learning from Unreasonable Hospitality, which is like go above and beyond always, not just with the people you're working for, but the people you're working with. And it just makes it better for everybody. So I'm really enjoying the book.
Great. Well, thoroughly enjoyed having you come on today. If people want to connect with you, learn more about WUCIOA, attend one of your classes, what's the best way for people to do so?
I am on LinkedIn, Adriana Clifton. I've started using that more. I'm like young, I think Gen Z. So I was like looking at TikTok and Instagram and being like, oh, how can I use this? And LinkedIn seemed different to me, but I'm trying to, bridge that gap a little more and apply what I know about TikTok, Instagram, YouTube to LinkedIn. So you can find me there. And then my website is just cliftonlawpllc.com.
Great. We'll put links to all those on this video. Want to say thank you so much for coming on with us today.
Thank you so much for having me.
Yeah, thank you so much, Adrian.